before we get started, I do want to, I've mentioned this a few times throughout the proceedings. We obviously spend a lot of time together. That 2.5 week portion, that doesn't include the many pre-trials and court dates we had over the summer and the spring leading up to this trial. I again want to commend the attorneys for how this case was handled from beginning to end since I took it over. I know it was a lot of work. I was present for a lot of that work and a lot of the hearings and the depositions, and the motion practice argument, and I want to thank you guys for how you guys handled the proceedings in a very difficult case. I don't have too much to say. A couple things I do want to add is what I find most sad about these cases. What's sad about these cases is the impact it has on people beyond this courtroom. Although it's the state of Florida versus Johnathan Quiles, this court has been filled with people beyond that. Aunts, uncles, grandparents, cousins, and even on the defense side, his brother, his aunts, his cousins. And then what goes unmentioned is his 5 children. And per my math, one of them was probably born a month after he was arrested. He's probably maybe 4 to 5 years old now. And none of those 5. Although they have to live with this, they don't deserve that. It just shows you the impact of one decision impacts so many people beyond the criminal justice system. The last thing I want to add is the testimony came out during trial. The family found out early December the 3rd, and then the rest of the family found out December 6th. Regarding Iyana's pregnancy. She had no B visit on December 13th. I recall the testimony coming out that the child, at that point, the pregnancy was 22 weeks and 5 days. And if you do the math, 6 days later, December 19th, she would have been 23 weeks and 4 days. Two people were murdered. That baby could feel love and comfort. sadly, because of Mr. Quiles, he made sure it felt pain. But that baby was a real person. I find some comfort knowing that she was with her mother at the time. Sir, you can stand with your attorneys at the podium. So, Mr. Quiles, you were found guilty by a jury of your peers on all 3 counts of the indictment, the only difference being that the jury found you guilty and made a finding of that you discharged the firearm. As to count 1, you're adjudicated guilty of that offense. You're sentenced to life in prison with a 20-year minimum mandatory as required by Florida law. You have 1,537 days credit. As to count 2, you're adjudicated guilty. You're sentenced to life in prison. You have 0 days credit. Count 2 is consecutive to count 1. Count 3, the sexual battery charge, you were adjudged guilty. You're sentenced to life in prison. Count with 0 days credit. Count 3 is consecutive to count 2. Count 3 does carry surcharges of $201, $151, and $151 as required by Florida statutes. State anything else you need to add?
Just that he is designated a sex predator, does he get a record, Your Honor?
I did sign the order designating him a sexual predator, and it will be filed with the clerk's office today.
And that is all, Your Honor, thank you.
Defense, anything from defense?
No, Your Honor.
If I didn't say so, and maybe I know I announced the 20-year min-man on count 1, there's also that 20-year min-man on count 2 as well. I think everything else I covered in my other sentence. There is $518 in court costs and a $50 PD application lien, if I didn't say so. State, last chance to capture everything.
Yes, Your Honor, that's all I can think of now that you put the designation as well.
Anything I need to clarify?
No, Your Honor.
If anything I need to add or clarify?
No, Your Honor.
All right, thank you guys. I hope, I know it's been a long 4.5 years. Hopefully it brings some kind of closure to both sides, especially the Mobley and Sawyer family. So with that said, we'll be in recess. Oh, I'm sorry, hold on a second. Sir, you do have 30 days to feel the legality of this sentence. And so now we'll be in recess.
Yes, learn something new all the time, Your Honor.